Hey guys, thanks for checking in at Zero Pettifoggery, sir. This is episode 5, um, touching upon a few pretty interesting topics. I got Marauding for Your Ears coming back this week. Didn't have it last week. A pretty humorous and interesting case coming out of Oakland, New Jersey, regarding Hernandez and an attorney, John Robertelli, and a bunch of other information I think you'll find useful. So look forward to your questions, comments, and feedback. Thanks. Hey guys, Wednesday, May 27th, about 10:30 p.m. Got a quick update. Third Circuit, which is the district court, federal court for the state of New Jersey, recently put down an opinion in the matter of Bacon versus Avis Budget Group. That's number 18-3780. The decision, reason why I'm kind of bringing you guys this information is because it speaks to an issue which I think a lot of consumers deal with on a regular basis, and that is arbitration agreements. In this case, there was a one-page agreement that was signed in order for the customer to rent this vehicle. It said that essentially, I agreed to the charges listed above as estimates, and I reviewed all notices and terms here and in the rental jacket. So, after the person who rented the car signed the agreement, they folded the agreement and they placed it inside the rental jacket, quote unquote, and the rental jacket was providing a folder that included about 31 paragraphs of terms and conditions to the contract that the person was agreeing to. And the rental associate said nothing about the rental jacket, and so the car was rented. The details of the transaction kind of were glossed over, and everybody moved forward. The car was rented, the person used the car, etc. So what essentially happened was there was a class action lawsuit against Avis for the usage of this arbitration agreement, partially because I think as consumers we all understand that arbitration is a way that a lot of bigger companies force disputes to go to an almost what some would consider an informal party, to have their situations resolved in a cheaper and more cost-effective fashion, and get to the point pretty quickly, resolve a case pretty quickly, resolve a situation and a dispute. And I'm sure that many of you have agreed to arbitration terms in many contracts. Notably, that would probably be your mobile device, whether AT&T or Sprint or T-Mobile, Verizon. I'm sure that when you signed off to have their services, or the cell phone, or leasing the phone, you agreed to an arbitration agreement. And what that does is it prevents the company from having to expend a decent amount of money in litigation, following you ending up in a dispute and wanting to sue them. So in this circumstance, very similar, Avis tried to do the same thing. And essentially what the argument was saying, and what the decision by the Third Circuit said, is the rental jacket was not adequately incorporated into the agreement itself. So a person signed off on the agreement, and it had 31 paragraphs, but all they saw was the first page. They signed the first page, it was tucked into a folder. Here's your folder, it includes 31 paragraphs, and they didn't agree to those paragraphs. Now, most people are not going to make an argument over those types of things. Most people are going to gloss over those terms, but in the end, depending on the transaction, a lot of these terms and conditions have impacts on your potential litigation. Being in court and suing for things that have been done wrong to you, or breaches of contract, is a very important recourse for a lot of citizens, and having them forced into arbitration is a quick, I wouldn't say painless way, but a quick way to have these types of claims shoved aside, resolved quickly, and out of sight, out of mind for these big companies. So in this circumstance, they didn't apply the arbitration agreement because of this separation. It was one page, and then here's a 31 paragraph rental jacket. So lesson here: read your contracts. Read. I know that they're not exciting. I know this is not fun information, but read your contracts. I'm not just talking about your wireless plan, whether or not that's 15 to 20 pages and, type font 6 or whatnot. Read your contracts. Always get copies of your contracts. Make sure you understand the terms in your contracts for any types of purchases, whether it's lease agreements or car purchases or construction or any types of contracts you're making for any large purchases. Anything over $500 up to $1,000, you really need to have these contracts, have these terms understood. And of course, if you need to have these contracts reviewed, do not hesitate to contact an attorney. I certainly do that, and I certainly would encourage people to reach out to me if need be. So just a little tidbit of information. Hope it's helpful. Thanks.
Hey guys, coming to you live from Mima's Rosebush, gracing the front of our house and my office right now. And this week's segment is Marauding for Your Ears, is the podcast Caught. The basis of it is the juvenile justice system, and which I practice in very frequently. The podcast goes to discuss different juveniles and their cases and the things that they go through, and it focuses in on kids making mistakes, and depending on their race, their zip code, their financial status, what mistakes become lasting impacts. So wherever you get your podcast, check it out. It's called Caught, CAUGHT, and let me know what you think. Thanks. Hey guys, May 29th, about 3 p.m. Wanted to give you a little anecdotal, pretty interesting story that some people might find interesting. A New Jersey attorney by the name of John Robert Telly of Rivkin and Radler in Hackensack is facing admonition for instructing his paralegal to become a Facebook friend of a person that was currently suing his client. The basis of this case is pretty interesting. I won't get into too much specifics, but Dennis Hernandez is alleged to be doing sit-ups in a parking lot when he happens to be struck by a Borough of Oakland police cruiser. And I'll say that certainly I'm not stating these facts like they are absolute truths or beyond investigation. Just giving you the information as I know it and as I've been told. I haven't verified any of this information, so understand that those facts are just allegations at this point. From the accident, essentially, Mr. Robert Telly, who's representing presumably the Borough of Oakland in this circumstance, gets allegations from Mr. Hernandez that he had a broken pelvis and a broken leg. So the case dates back to 2007, unbelievably. And interestingly enough, the case goes into a new area of law and a new area of the rules of model penal code, model professional code, pardon me, that govern how attorneys can handle matters ethically. And in this circumstance, the disciplinary review board is recommending an admonition of Robert Telly while attempting to kind of set a baseline decision on social media being used for discovery purposes. If you don't know, discovery is the exchange of evidence between parties in the middle of a lawsuit. So essentially, first and foremost, all public information that's provided on social media can be accessed and is absolutely permissible for all parties to track down and achieve. The next thing that they're recommending is, however, if it's otherwise private information and it's going to be accessed for gain of a represented party, it's considered improper communication. And then the next part is accessing an individual's social media, whether or not that person is represented or not, without disclosing who is making that request and the purpose of the request, can be considered dishonesty, fraud, deceit, or misrepresentation within the rules of the professional conduct of an attorney. So in this circumstance, you had a plaintiff, Mr. Hernandez, who was suing Mr. Robertelli and his firm, defending the Borough of Oakland and as well as the defendants. And Mr. Robertelli initially instructed his paralegal to view his public profile. He or she had done so, pardon me. And next thing is the plaintiff changed his profile from public to private, in which spurned the paralegal to send messages to the plaintiff to try and solicit more information. And then next, the attorney instructed the paralegal to friend the plaintiff in order to find out more information. So out of it, Mr. Robertelli and the paralegal seemed to turn up a video of the plaintiff who was wrestling with his brother on Facebook in a video, which was right around the time in which the accident had happened. And obviously that would refute any allegation that he had a broken pelvis as well as a broken leg. So pretty interesting case. There's a grievance going on with the Office of Attorney Ethics. There's the review board in terms of determining if there should be discipline to this attorney regarding this circumstance. But pretty interesting case. I think it has a lot of implications for a lot of people. You should be very careful about what you post on social media, and especially if you're involved in litigation. You should be very careful as to what is public and what is private. Understand that the moment that you post things, regardless of it being public or private, there are people that have access to it. They have the ability to disseminate it and distribute it in any way that they would like. And especially if you're involved in litigation, the things that you say, the things that you post can be a public record. Certainly a public record to be discovered in litigation that could hurt or harm your case. So pretty interesting stuff there. That was from a New Jersey Law Journal article, came out on May 14th. So hope you enjoy. Thanks.
Put your hand down. Why are you smiling? Cause I love the law. The law is fun. Fun, sir. It's fun? Yes. You sure? I think. Now you're thinking. First you smile, then you're thinking. You think the law is still fun? Yes. Sir. Yes. No, sir. No. It was fun. Not anymore though, is it? Is it? Not right now. It's not fun anymore? Not even a little bit. No. Make up your mind. Think, since you're thinking. Go on, think. Is it fun? No, sir. No? Absolutely not? Zero. Pettifoggery, sir. All right, listen up. I'm Daniel F. Deraney, and I'm going to tell you how much fun you're going to have this episode.